For more on this striking day of testimony, we bring in ABC News contributor Channa Lloyd from the Cochran firm. Channa, always good to have you on. Let's start with the defense's motion for a mistrial with prejudice. How likely are they to win that? And if they do, that essentially ends this case, right?
Essentially, if it's granted, it does end the case. The thing with a mistrial is that it's a very high burden because it's a very drastic measure for a trial. Typically, a court is going to look to see if there's going to be a lesser measure, like, for instance, a curative instruction to the jury that will basically smooth over anything that may have occurred in trial. They are going to have to show that there was substantial and irreparable damage and prejudice to the defendant before a mistrial can be granted.
Though, in fairness, you really can't unring that bell once the cat is kind of out of the bag, even though you can instruct the jury to say, strike that, don't let that be part of your decision-making. Perhaps they have been prejudiced, correct?
Absolutely. I mean, it is hard to unring the bell, but certain things are much more prejudicial. If he had gone into the full entirety of the incident, that would definitely probably rise to the level of a mistrial. But, you know, alluding to it and then being cut off, I don't know if that rises to the level in this particular case, which is why I think the judge is being very cautious about granting this mistrial, because there is a curative instruction that he could issue to the jury for that, what was said today.
Okay, let's take a listen to more of Rittenhouse's testimony.
What was the risk to you of death or great bodily harm at the moment you killed Joseph Rosenbaum?
If I would have let Mr. Rosenbaum take my firearm from me, he would have used it and killed me with it and probably killed more people if I would have let him get my gun.
Rittenhouse says that Joseph Rosenbaum touched his gun but never touched him, and we also hear his claim that Rosenbaum could have killed him and others had he not shot him. Was that a strong self-defense argument?
I think it's the strongest argument he has. Remember, we're always in the mind of the defendant when it comes to self-defense. Did he reasonably believe that he was in imminent fear of grave bodily harm? Or so when we look at this, we have to look at who he is, the position he was in, where he was, and what was occurring at that time. So it is subjective in some ways because we have to put ourselves in his shoes to make that determination.
Then Rittenhouse also defended his killing of Anthony Huber, saying that Huber hit him twice with a skateboard and grabbed his gun. But the prosecutor drilled down on that. Let's take a listen.
And when you shoot him, he's got his skateboard in his hand?
Yes.
You didn't see any gun in his hand, correct?
No.
You didn't see a knife?
No.
You didn't see a bat?
No.
You didn't see a club?
No.
All he's got is the skateboard, right?
That he's hit me in the head with twice, yes.
Okay. And you intended to pull the trigger at that moment with your AR-15, correct?
Yes.
That wasn't an accident.
No.
That was your deliberate decision, correct?
Yes.
And you knew that the way that gun was positioned, you were going to fire that bullet right into his chest, right?
He was attacking me, so I pulled the trigger.
Channa, what do you make of that defense?
That one is a little bit different. I mean, here we have the skateboard, which some could seem to possibly be some sort of dangerous instrument. However, we really have to look at the instance. Was he able to get away? You know, he wasn't at the time, although he had been hit twice, his vision wasn't impaired. You know, there are other things that people are going to look at and the jurors are going to look at when they make that assessment as to whether or not he could have gotten away, whether or not it rose to the level of having to actually shoot and hit someone in that nature. It really has to rise to the fact that you believe that you are actually about to be harmed physically and that this type of force is necessary.
And lastly, do you think that Rittenhouse helped or hurt his case by taking the stand?
Interestingly enough, Linsey, I think today it's going to go a little bit of both ways, I think, depending on the juror. I think seeing him on the stand, hearing it from his point of view, he was clearly very well prepared for this. He stuck to his speaking points initially, but seeing the raw emotion come out of him is going to humanize him to a jury. And there are going to be people that see him and see that emotion and see the panic that he was feeling on the stand and feel that maybe he did feel as though he was in danger. He had no other options. You know, he was on the ground. There was nothing else he could have done. So I think humanizing him to the jury is going to definitely appeal to some of our jury members. On the other hand, I also think that the very same emotion, the ability not to be able to compose himself, I think is also going to strike some jurors to say if he doesn't have the emotional wherewithal to control himself, he should have really not been in a position to have the firearm in the first place, thereby being in a situation that was as volatile as it was. So I think depending on the jury, this is going to slide a little bit on each side of the mantle, if you ask me.
Points well taken. Channa Lloyd, thank you so much.
Always a pleasure, Linsey.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.